The purpose of today's mention was twofold, Your Honor. One, bail terms. Us of the intended charges against our client. The client has religiously been complying with the attendance, that is on Tuesday and Thursdays at the DPP headquarters, Kiambu Road. And secondly, he posted the cash bail the same day. He deposited his passport the same day. Actually, we counsel assisted him to process him out because time was running out against him. So he has complied with all the terms that you set and imposed against him. And he was set at liberty. In spite of your order, Your Honor, the police abducted him and they drove him, and at Keno along Thika Superhighway, they blindfolded him. Then they took him to a place, and the amount of time that they took from Keno to wherever to the destination of torture at the detention was 1 hour. Your Honor, they also abducted his father on the same day, under the same circumstance and treatment. And dare I say, very primitive treatment which cannot be countenanced this day and age. However, they released the father yesterday, and the father is the one who narrated to us what he underwent. The torture, merely because of making the mistake of being the father or bearing his son, who is your respondent. Your Honor, I must specify the torturous moments that he underwent for record purposes. They put a tin container on his head, and then they shot at it. For intimidation and trauma purposes. The torture that is happening at that detention camp is also taking the form of the other abductees. This is very important even for my client. The other abductees are being held incommunicado and tied. Their arms are being tied. And then they are being tortured there. This day and age we don't expect to be taken back to those dark moments, Your Honor. At the trauma and torture and constitutionally. Your Honor, there is a reason why we have administration of justice system. It is to make sure that any dispute between citizens or between the state and the citizens is resolved through one of the three arms of the government. Orderly manner as prescribed in the Constitution and other penal laws. When the state decides and actively disobeys court orders, that is brazen contempt of court, and it amounts to undermining the administration of justice. It also has the dire effect and damage to the faith and trust that the people of the Republic of Kenya have in court and the judiciary. Therefore, it behoves upon this honorable court, Your Honor, to make sure that your orders are obeyed by the state in full. In order to preserve and protect the integrity of the administration of justice. To that end, we are making the following habeas application: that the state and the police, and specifically the DCI, does produce the respondent in the course of the day, in any event before 2 p.m. today. And for the substance of that argument, I'm going to invite my learned colleague, Mr. Jiro, to converse on the same.
Good morning. For you, and is not for you. And his failure to appear before you has been occasioned by the state. The application you are doing before you on behalf of the respondent in his absentia is premised on reasonable belief that the respondent is in the custody of the police. Your Honor, identified as police, there is a prima facie presumption that the respondent is equally in the hands of the police. Why, Your Honor? Because of the nexus between the cause of the father's abduction and the son. So on that basis, therefore, Your Honor, that we move you on Article 10, Article 49, Clause 1, Paragraph F. We equally move you, Your Honor, under Section 8 of the Magistrates Act that confers you with jurisdiction to hear any violation. Then I would just have a magistrate court shall have jurisdiction to hear and determine applications for redress of a denial, violation, or infringement of or threat to a right or fundamental freedom in the Bill of Rights. You know, the articles that I have quoted, that is Article 19, 20, 24, 25, and 46, 9, falls under the Bill of Rights. With Section 8, Subsection 1 is addressing. It's on therefore that basis, therefore, that we make our application for habeas corpus before you. And Article 25, paragraph D. This court is clothed with jurisdiction to issue orders to the state and, most importantly, to the IG of the police to produce the body, dead or alive. That is the essence of habeas corpus. We made reports to the Goto police station that our client is missing. So this is information that is in the custody of the police. Let the IG be summoned before you and come and tell us what actions have been taken in respect to the report that has been filed before them. In the alternative, they produce the body, dead or alive. You know, Article 25 cannot be limited by whatsoever nature, by whatsoever status of an individual, by whatsoever hour, not even you, Your Honor, that can limit that right. Not even the President or the Chief Justice, not even Parliament. Nobody can limit that right, Your Honor. And as we speak, Your Honor, there is no respondent before you, courtesy of the police. Even the devil deserves justice. Article 48 provides that he must be produced before a court of law within 24 hours. Why is he being held incommunicado by the police? He's not allowed to access his advocates. He's not allowed to access his family members. None of the family members, including the wife and his children as young as 4 years, knows where their father and their husband and their loved one is. And most importantly, ourselves, who represent him. Courtesy of a mere allegation of what I've seen the nation calling haste. Doesn't the devil even deserve justice? You know, if the devil was to appear before you this morning, would you take him to the eternal fire without hearing him and giving my fair an opportunity? You know, our application is very simple and precise. Habeas corpus. And even as we go for habeas corpus, Your Honor, let the state tell us why they are maintaining the current proceedings. I can see the IOA is here. He can take the stance. We can cross-examine him on that basis. Thought, Your Honor, before we got that link, habeas corpus be issued. Then we can address the issues of the status of the business application. We are most obliged, Your Honor.
Shoot myself fully with the application, sentiments, and feelings of fellow counsel on the matter. It's weighty. We equally have had sleepless nights. We are worried. Sunday to today is not 24 hours. It's many hours for anybody to be missing, courtesy of the very government that came to power and immediately after being sworn in disbanded an entire unit. We are worried. We are heading back there, and I wish to associate myself with the application. Habeas corpus, that the body be produced before you by 2 p.m. today. Thank you, Your Honor.
far as the prosecution and the investigators are concerned, the respondent in this matter is already in contempt of the orders issued by this court, that he should attend to the IO every Tuesday. So from the record, Your Honor, he only attended on the first Tuesday and Thursday after he left court. Your Honor, it has been submitted that the respondent was arrested by police and is in the custody of the police, who should produce him. But Your Honor, nothing has been produced before this honorable court to show, or rather to support that position. And that notwithstanding, counsel for the respondent, Your Honor, has informed court that indeed they have made a missing person report at Togoto Police Station. Though equally, no OB number has been produced to court. Your Honor, though no OB number has been produced before this honorable court, Your Honor, I would very humbly submit that the application for habeas corpus is a bit premature at this point. If indeed a missing person report has been filed, then the expectation is that the investigations should be allowed to take their course, and a finding of those investigations then the advocate, Your Honor, can follow up on the findings of those investigations. Your Honor, this court has been drawn to various media Your Honor, various media reports which the prosecution is not seized of, neither the investigation team. And I will urge, Your Honor, that this matter is not to be canvassed through the media. This is a matter that is before court. And for that reason, Your Honor, I would pray that I humbly submit that the same should not be sensationalized, and that due process be followed. The issue of the father to the respondent having been arrested by the police and released thereafter, Your Honor, equally, nothing has been produced in support of that allegation to court. And be that as it may, Your Honor, the matter that is before you does not touch on the father or any other relative of the respondent. And equally, Your Honor, we would pray that Your Honor, our focus, Your Honor, remains on the respondent who is before court, and as things stand now, he is absent. The only inference, Your Honor, is that the respondent has absconded this honorable court. and is in contempt of the orders issued by the court. And for that reason, Your Honor, we shall be constrained in the circumstances to pray for warrants of arrest for the respondent who is not present today, having been aware of today's mentioned dates. Your Honor, in conclusion, we wish to very humbly submit that when the respondent was first arraigned in court, it was in fact the defense team that vehemently made an application to court that the respondent should be released on bail bond. Your Honor, then it defeats logic that they could have been seeking that their client be released on bail bond terms. Yet, the police were waiting to, with the police, Your Honor, waiting to arrest him and torture him, as has been alleged. Your Honor, we find that to be quite the paradox, and pray that the court is not drawn into the sensationalization that is being brought about by the defense, and that the issues, the generalization of the issues, Your Honor, the father and the respondent is avoided. For that reason, Your Honor, we we reiterate our application that the warrants of arrest be issued against the accused person, against the respondent, and that Your Honor, that will be
Mr. Delwan to address you on the issue and diverged the intended case before this honorable court, which you find highly immoral, premature, and highly prejudicial to our client. Secondly, the prosecution itself has let out the cat from the bag during their opening remark. They told you that the respondent has not been attending the sessions he's supposed to religiously, and that he only attended twice at the DCIs. They were, in other words, telling you they arrested him because of not coming to them. That is an invitation towards that conclusion, unavoidably. Your Honor, thirdly, and most sadly, the DPP should take the liberties of citizens seriously. The way he had addressed you very casually and in a very jocular manner is most unfortunate. The liberties of citizens is so paramount that it is one of the reasons why we came up with a new constitution, the liberties of citizens. It's one of the leading reasons why we have the new constitution, because of the violation of the same by the former constitutional order. DPP is simply telling you to issue a warrant of arrest in order to arrest a person they have already arrested and is in their custody. That's casualness, Your Honor, and it should not be entertained at all. So I'm going to invite my learned colleague, Mr. Giro, to address you on the issue of the OB extract.
I will
Thank you.
be very brief, Your Honor. To cited are not applicable in the submissions. Council has not rebutted the applicability of Section 8 of the Magistrate Act. Council has not told you that we do not have the ability and the power to invoke Article 50D. Therefore, my arguments on aspects of law are unrebutted. And because my arguments in Regeda must be on points of law, allow me, Your Honor, to introduce facts that I had alluded to in respect of the OB, that the wife to the respondent, one Susan Wariga, recorded complaint on a missing person via OBs 05 12 stroke 8 stroke 24 05 12 8 24 at 0:30 hours on the 12th of August at Kikuyu police station. We can perhaps...
No problem. No problem.
You know, I thought, Lee, that in rebuttal you allow me to introduce this because I've mentioned it. And I think it's in good order under the Evidence Act. There are documents such as this one. It's presumption of a client wife has recorded a complaint in respect to a missing person. You know, our humble prayer is very simple. You invoke Article 25. The DPP has not addressed you on that aspect. When somebody is missing for 24 hours, more than 24 hours, this person was abducted by the police, the court can invoke that jurisdiction. And as such, Your Honor, we commit the respondents to your hands. The baby is with you. We wash our hands like Pinter's pirate.
At Kikuyu police station. Your Honor, that notwithstanding, we reiterate that a missing person report has been made. And just like we had submitted, that it would be premature to then...
I think I was only supposed to comment on the OB, not to submit further, and I give him that latitude because we have introduced new facts, he had the right to respond on it, but he cannot further it.
Yes, Your Honor, we reiterate that a missing person report has been made, and the defense should allow for investigations into that report to be undertaken.
Most obliged.
Mwirigi Kimathi.